Hi everybody, it's Attorney Goff. I was actually live a few minutes ago with the trivia answer, and then I had a bright idea. I said, why do I not do the video segment I'm going to do tonight, because it just makes more sense. And actually we had a lot of viewers from the Trivia Tuesday. And I'm already in a suit, so why put on another suit if I don't have to? So firstly, this session, I do a lot of comp stuff, but I get so many requests for it, and it is one of the most common injuries in the state of Connecticut. I see more comp cases than I see really anything, because people are working every day and they get injured every day. And firstly, how I want to start this out is I want to talk about just the filing of the claim. I'll spend just a couple of minutes on that. I talk about that in all these segments, but it's just so important you understand. Then I'm going to get into the type of benefits, because anybody that's had a comp claim or will have a comp claim, you're going to know what I'm talking about. You hear the words TT, PPD, TPD, and it's like hard to keep everything straight. I'm going to wrap it up, remind you guys about some of the benefits. You also have choosing of the doctor, the mileage, et cetera, et cetera. So we'll get into that. So firstly, let's start about filing a claim. Employee is injured at work. All right, let's just say he works for John Smith's Towing. He's injured at work, hurts his foot. What does he do? First, if you need medical attention, you need to call for medical attention. If you're by yourself, make sure you call for medical attention. Do that first and foremost, okay? If it's not an emergency, you should report that to your employer that you've been injured at the workspace and that you need medical attention. Or if you don't need medical attention at that time, you just need to alert your employer. And I would definitely ask to do a case report, incident report is what we call them, because sometimes we run into this where the employer tries to deny the claim. Oh, it didn't happen at work. He never complained, or she never complained. So you want to make sure you get this form filed. You get this filed right in the beginning. That way you stave off any kind of problems you're going to have later on. Your employer may also have you fill out a first report of injury, which is great. That's part of how you file the claim initially. But what the statute says is that you should be filing a 30C. But this is after you get the medical attention. So you get injured, you report to your employer. Let's say you get your medical attention. The physician of the hospital says you're out of work for 5 days or what have you. You have to notify your employer of that right away. All right, don't hide it. Don't worry about your job. Do not dishonor the doctor's instructions. Okay, follow the doctor's instructions. You're only asking for trouble if you don't. Report it to your employer. Then do what the doctor says. All right. So now your employer knows that you're out of work for 5 days, and the next step is that you have to file this 30C form. So it's easy. Why? It's not easy, but the form is easy to get. The form is easy to get because you go online, you can type in 30C form, and it fills out right there. It's a fillable form. You have to print it out. And here's the thing, guys. You have got to certify it to your employer and to the comp office that's going to have jurisdiction, okay? If you do not do that, you are not following the statute, okay? So it says that you have got to send it certified. Don't forget it. Don't try to save $5. I think it's like $7 on a file certified or something crazy. But you got to send it certified to both the employer and to the workers' comp office that you're going to be filing in. Now, here's the other thing you have to understand. You have 1 year to file this form, but the earlier you file it, the better, because you're only protecting yourself. The form asks your name, date of birth, where you work, where the injury happened, what body parts you've injured, this kind of thing. And it's one of the most important forms in the case. If you do not file this within 1 year, then you could be forever barred from bringing your case. Very, very important. I will tell you, if you're considering getting a lawyer, meeting with a lawyer, you should definitely do that in the beginning as early as possible, because why are you going to do the work on your own and then hire a lawyer later? It's stupid. And the attorney will file this 30C form because it's technically a legal document. So I would say, especially, I would always tell everybody, whether you decide to get a lawyer involved or not, you should meet with a lawyer in the first week, okay? Any good lawyer will make time for you in a couple days span. And if they're too busy, move on. Or they will come to you too. So a lot of attorneys do. My office does it. Obviously, we make an appointment to do that. We offer that service to our clients, knowing that a lot of people, unfortunately, cannot get around after a work injury. So this 30C form is important, but like I said, if you're getting a lawyer, you're considering getting a lawyer, I tell everybody that's ever injured at work, just meet with a lawyer initially, then make your decision. If you have an attorney that's on the other side of the table trying to force you to sign, kind of pushing the papers at you quickly, run. I mean, honestly, I tell most of my clients, take it home, read it, do whatever you got to do with the form, okay? And then we'll deal with it later. So I always, the only rush is to get the 30C filed. There's no problem as a client for you to get forms from the attorney and you to take them home and read them with your spouse and then follow up in a day or so. I mean, it happens all the time. And as your client, you have that right. All right. So that's the what I recommend. So the 30C piece, if you're considering a lawyer, which again I recommend you meet with one in the first week, then the lawyer would file it. However, if you wanted to give it a go, and this is what you choose to do, that form needs to be filed within the 1 year point. Just file it right away. It's got to be certified to the employer and to the comp commission. Make sure you send it to the right comp commission, okay? Secondly is a 1A form. So you can get this online as well. I'm going to show you one thing on the 1A form. So the 1A form is how we come up with your comp rate, which might not make a lot of sense, but a comp rate is one of the most important parts of a case, okay? One of the most important parts of the case. Your comp rate determines what the value of the case is down the road, determines what your benefits are, determines how much you get every week, determines how much your rating ends up equalizing to. It depends on everything, okay? So you need to understand that the 1A form is important, and this is how we gather this information. It asks for your name, then it asks how you file, single, married, filing jointly, head of household, this type of filing. You mark it down, and then you put in the name of your exemptions. If you're married and you file jointly, yes, your wife is or your husband's an exemption. So put all that down, okay? Then the next step is there's a section called concurrent employment. A lot of people don't know what this means. They just think they have to put in their employer's name. No. If you have a second job, I don't care if you waitress, I don't care if you're a barista at Starbucks, I don't care what it is, that needs to be included because that's included as part of your comp rate, and we actually get somebody in the case called the Second Injury Fund, which is the state of Connecticut. So your comp rate actually takes that into account and goes up, okay? So concurrent employment is key, and this is where you put it. That's what that box means, right? Many people, 80% of people fill that out wrong. Concurrent employment. So let's say you are working for the state of Connecticut as a corrections officer today, and then you have concurrent employment doing a Starbucks barista, right? You're going to put concurrent employment Starbucks barista, date started, date ending, and then obviously you're going to have to get the 52-week pay history, or your attorney will do it from them, which is a process. You have to put the Second Injury Fund on notice. So again, concurrent employment, it's a process. This is something for a lawyer to handle, but understand that's what that box means. It's not asking you for the employer that's current on your case, which would be the state of Connecticut if you worked for the state of Connecticut. It's asking for concurrent employment. Who else do you work for at the time of the injury? Not who you worked for 2 years before the injury, who you worked at the time of the injury. That 1A form is then sent to comp and to hopefully you know who the insurance company is at that time, the insurance company. And once they get that form, then they can calculate your 1A, and actually it helps the commissioner approve what's called the jurisdictional VAs. So let's just say they get your 52-week wage history from your current employer. Let's say the state of Connecticut's your employer, the current employer. Then we get your 1A form, which says you filed married filing jointly with 3 exemptions. You're married with 2 kids. So it'd be married with 1 kid because it's 2 exemptions. So yourself, wife, and let's just say you have 1 child. So you fill all that out. You have no concurrent employment, let's say, right? What we do is we take that 50-week, 2-week pay history. I've invested into a company called Comp Tools. A lot of attorneys don't have it. I don't know why. The defense attorneys have it. So whatever they have, I want better, right? That's the way everybody should be. And we plug the numbers in. It used to just be like 3 pages nonstop of math. Now forget about it. It's too daunting. So we use this tool, right? Pops out the comp rate. Then we figure out what your comp rate is. We send that comp rate to the insurance company at the time, or the attorney on the file, and we request it for jurisdictional voluntary agreements. This is what this jurisdictional VA or voluntary agreement states. This is what we all agree that your comp rate is. Let's say it's $500 a week, right? You're going to get a VA. It's going to say what your body part is. It's going to have your name, date of birth, all this other stuff on here. And then it's going to be on that same form that you worked for 30 weeks, an average pay of, let's say, I don't know, I'm making this number up, $30,000, which equals an average weekly wage of blank. We plug in, because you all know you don't get your full wages under comp, we plug that into Comp Tools, it pops out what your comp rate is. That's also in the form. As long as that comp rate's right, which again, once you sign these papers, you're agreeing, guys, and sometimes the commissioners don't catch it. So again, I'm not going to advocate for attorney this whole time, but I'm telling you, this is why you need a lawyer in comp. Then I say, yes, sir, Mr. Smith, your comp rate's right. Then you sign that form. Then you send it to the commissioner, and the commissioner approves it. What happens then? Now you have your comp rate. You know what your comp rate is. It's great. Commissioner's approved it. Everything's going to move smoothly. Okay? There's no question about you're getting paid too much, too little, you're owing money back, etc. It's all done. In the beginning, should be done in the first 60 days. Everybody's happy. Makes it easier to settle at the end too. So that's my spiel for the beginning of a case. So types of benefits. You probably hear TT. This means temporary total benefits, okay? This means you cannot work and now the insurance company is paying you because you cannot work. That's temporary total, okay? Temporarily, you're totally disabled, right? That's why you can't work. And those benefits, and this is my opinion, guys, this is not the statute, this is my opinion, should not be touched by an attorney unless it requires a trial, a comp trial. Many attorneys try to find any reason to touch these benefits just so they get paid because they feel like they're entitled to get paid because they've done all this work on your file and they haven't made any money, et cetera, et cetera. It's crap. And it's, my opinion, it's unethical. I do not touch TT benefits. The only time my office touches TT benefits is if I go to trial. When I say trial, guys, I mean it's a formal trial. It can go 3 to 4 different days over a period of 6 months or so. We have to wait we have to write briefs. We have to wait 4 months for a decision. It's serious stuff. That's the only time my office touches TT benefits. And why? Because it's a clear contested TT case. Those are rare, guys. 1 in 250 probably, if I had to guess. Most of the time, just because the insurance company files a form, like a Form 43, which is a standard form, most attorneys are like, ding, I'm gonna take a fee on the checks. That's crap. You guys aren't working. These people aren't working. They need the money. Like, don't do that. My office, I could make tens and probably close to $100,000 more a year if I just started to play in that game and doing the TT benefits. It's crap. It's wrong. I'm not desperate, and you deserve better. And why aren't you questioning your lawyer? If they're taking your TT benefits, guys, say, why are you taking my benefits? Where in my employment agreement does it let you? And what is your definition of contested benefits? I'm telling you, I see it all the time amongst my colleagues. These people are taking your money. Do not let them take your money, okay? If it's TT and they file a simple form and it's one hearing, guys, move on. Go to another attorney. Go to my office. I don't care. Go somewhere else. There are a lot of attorneys do this, so I can't tell you who doesn't, right? But I can tell you we don't. I don't touch your TT unless I go to a trial. And guys, I'm at trial because you're there with me, all right? And it's a very involved process. It's almost like trying a case, all right? Again, your attorney should not be touching your TT. If you're out of work and you're being paid for being out of work, right? And I don't care what the insurance files. If they delay your check for a week, some attorneys, you call your attorney and say, hey, attorney so-and-so, I didn't get paid this week. You figure out what's going on with my checks. All you did was fall off auto pay. That's it, which just means that they usually automatically pay you and you fell off. The attorney has to make a call. Oh, we got your benefits reinstated. Honest to God, I've heard the story. They then say, okay, your benefits are now contested. I'm going to start taking a fee. Don't fall for it. Don't do it, guys. It's terrible. And if you're suspicious of it, talk to the commissioner about it. But I'm telling you, don't get entangled in that. It says a lot about an attorney's character, and that's why we have a bad name. Do not do it or find an office that isn't so desperate that they need to do it. Okay? That's number one. You take a case on a contingency. You take the chance of having to work on it 1,000 hours to make a little bit of money. That's part of the arrangement. Deal with it. All right? So for you guys, protect yourselves. Do not ask when you meet with an attorney. If it's not me, ask, under what circumstances do you touch my TT? Oh, if it's contested, what do you consider contested? Oh, if they file a form, run. Okay? Because honestly, I've had cases, we just had a case. My law partner, Norma, who's fantastic, by the way. Shout out to Norma, right? She, I think probably 6 hearings, 7, would take TT for my clients. Why? This guy needs it. He's like going to be homeless. He could barely, he's lost checks for 6 weeks. No way. Unethical. Don't do it. Be aware of it. That's TT benefits. TPD, temporary partial disability. This means you have a light duty work capacity, sedentary capacity, sometimes what is said, and either your employer takes you back at light duty or they can't, right? And if you can't, you have to do something called light duty work searches in order to get your checks, all right? So this is called TPD. Again, I can't think of a situation besides a differential situation where we have to go to like a ton of hearings where this is touched. Honestly, the attorneys that touch TT usually touch TPD. All right. So again, I think in my entire career, TPD payment, I don't think we've ever touched a TPD payment. It doesn't make sense. Somebody's on light duty. Okay. They're doing work searches. You can't really, you can contest light duty work, I suppose, by sending them to an IME and everything. but it's still not contested, right? So if you, basically by the time they usually get to TPD, the TT's been worked out and the TPD kind of follows. That's temporary partial disability. You can work, but with restrictions. If your employer can accommodate the restrictions, great, right? You're back to work in a different, probably in a different job role. If they can't, then you do light-duty work searches. The forms are available online. You need to do these right away, guys. Insert these. The insurance company will just stop sending your checks. You're going to be like, what the hell happened? And then you're going to realize, oh, well, sir, we didn't get your light-duty work search. You're going to be like, what the hell is that? Because let me tell you, I've never been told that, right? So again, that's a light-duty, that's TPD status. And some people stay at TPD for months, 6-8 months, something along these lines. Then you have PPD, permanent partial disability. This is what the attorney's fee comes off of, okay? Permanent partial disability, this is your rating. If you get surgery, approximately a year after your surgery. If you don't get surgery, then usually it's a year after your injury, depending on how you heal, right? Everybody's a little different. So this is permanent partial disability. This is what those jurisdictional VAs I talked about, setting forth your comp rate, this is where they really come in here. So you're going to get a new voluntary agreement. It's on a green piece of paper, but it's going to have your rating on it now, right? And your comp rate you agreed to before. We utilize that, and then we plug in the body part, and that's how we calculate what you're owed, okay? So a back is worth 374 weeks. I know this because I know the guidelines, I know the book, and I know the assignment of the weeks. If you have a 10% rating of the back, that's 37.4 weeks. If your comp rate's $1,000, it's $37,400, right? But we calculate all that in a VA and a voluntary agreement. Then you sign that form again, right? Then the commissioner has to prove it again. Guys, if this is making your head spin, it's because it should make your head spin, and it should explain to you why you need a lawyer on these cases. I gotta tell you, my office does not make our money on comp. We do well on comp, but we get 20% versus 1/3 that we get on third-party cases. I do it because not enough good attorneys do it. And unfortunately, there's a shortage of good attorneys that do it, and every attorney thinks that they can do everything, and they can't. And comp is one of them. The first cases I've handled were comp cases. I got nitty. I wanted to know everything and anything, and I tore every comp case that was in front of me apart, every nook and cranny of it. I challenged. We made law. We did all of it. And it made me a damn good comp attorney. And I stand behind my cases that I would bring to comp. I stand behind what I ask for in comp. And I stand behind my demands, my hearing requests in comp. And that's what makes me a good lawyer, all right? Very few attorneys can tell you that they've tried multiple comp cases in their career. Most haven't tried one. Very few attorneys can tell you that they have made law in comp. And we've been cited in 3. So you have to understand, comp is an animal because a lot of these rules are at the commissioner's discretion, meaning the commissioner decides what the rule means, what the statute means, okay? So one commissioner might say, oh, I read it this way, and another might say, I read it this way. So no two comp cases are the same. One more thing I want to throw at you is, I get this all the time. Let's say I have a case, the guy hurts his back, right? And it gets a 10% rating, right? And then his buddy hurt his back, and he got a 10% rating 5 years before. His buddy got 100,000 and he got 20. And he's like, my buddy had the same injury, same workplace, same everything. I don't understand it. But guess what? His buddy's comp rate was $1,000 and his comp rate's $200. Guys, comp is numbers. That's it. All right. So it is numbers, and it's hard numbers, and it's confusing numbers, but it's numbers. There's no pain and suffering. So it's not like cases can deviate too much. The deviating factor in these cases are your comp rate. If you make $200, your buddy makes $1,000. Guess what that means? That is what you think it means. He's going to settle for 5 times more than you are. It's the numbers. I didn't make it up. That's not how I make it up. But the reason why I do comp is because this is why it's so important that you get every single nook and cranny, every single benefit available to you. And pro se, meaning representing yourself, I guarantee you won't. I challenge you, bring me a case that you've handled yourself. I will find something you didn't get. I'm telling you. Challenge you. And if you didn't, I'll shake your hand and I'm going to be like, you know what? You should go to law school. You absolutely should. You should go to law school, be a comp attorney. Very few of my clients have ever come in and been fully compensated for. I get people that come in, they didn't even know they're supposed to get a rating. I mean, they broke their elbow, they had surgery, and they didn't know they're supposed to get a rating. Guess what? We turn around, we get a 15% rating equals, they get a $15,000 to $20,000 check. They didn't even know that they would have been entitled to unless they saw one of these videos, okay? It happens every day. Mileage. People are like, what do you mean mileage? What do you mean? My adjuster never said that. Why would they say that? Because they have to pay you for it. Of course they're not going to say it. It's up to you to figure it out, guys. That if you want to take your case into your hands, you're expected to know everything. And let me tell you, most attorneys don't know everything. So you're undergoing a huge task, and it's going to take over your life. It's going to strain your relationship. And then you're going to be in my office anyways after you've done most of the work, and you're still going to pay me the same fee. So we work on a contingency. It makes sense. We make 20% at the end of the case. I could attend 10 hearings. I could expend hundreds of dollars in medical records, typically not the case in comp. I could do whatever. I could have 10 meetings with you, 40 emails, 100 phone calls, whatever the case may be. I get paid at the end. It's 20%, okay? Settlement. Insurance companies don't have to settle, guys, okay? People say this to me all the time. Can we go to trial? No. Unless you have an issue that takes you to a formal, unless you have a contested issue, no, you can't go to trial and make them settle. The commissioner can't make the comp company settle. So what does that mean? That means you have to have a good attorney that knows the system, that can put together demand and advocate for you and try to get it resolved. I have a client, she brought her case in, it was, I think, 7 or 8 years old. By the time your case gets that old, guys, your value is very limited. Every year that goes by, your risk level goes down because your life expectancy goes down. It's morbid, but it's the way it is. So if you're 6 years out of a case, they don't really have much upside to settle it. Well, guess what? Their offer was $5,000 before she came in. We settled it for $20,000. All right. So again, listen to me when I tell you, I'm not doing these videos to advocate and to get business. I don't need to. All right. I do this so that you can see and help yourself. Understand that this is bigger than you. Comp is bigger than any of you unless you're a comp attorney. Unless you're in comp every day, unless you've made these mix-ups, unless you've been in front of a commissioner, unless you've been screamed at, unless you've read the books, unless you've practiced it, unless you've been in the situations. Unless you know the lawyers. Guys, it's bigger than you. It's going to strain your relationship. And by the time you get 2 years in, you're already going to be checked out. And now you're going to hire me to pay me for what you honestly should have just hired me 2 years ago and I would have got the same fee. Don't make the mistake that most people do it. Get ahead of the problem. You get ahead of the problem in your life, get ahead of this problem. A couple more things. Mileage. Your paid mileage to and from doctor's appointments round trip, people, okay? So I think it's like 58.5 cents a mile. Don't quote me. I think it's 58 point something cents a mile. That's huge. If you have 600 miles, that's $300. A little more than $300. It's huge. Submit them every 30 days. The insurance companies hang on to them forever. I don't know what to tell you. But you stay on. If you have an attorney, your attorney will handle that. I can tell you right now, my client gave us our miles 3 weeks ago. We got it paid. She got a check today. She's happy. Why? She didn't even know she was supposed to get miles. Also, guys, if you don't have a car, right, and you need to see a doctor from comp, do you know that workers' comp has to provide you transportation? You probably didn't, right? So let's just say you have an appointment that's kind of far, right? I don't know. You need to go to Hartford, or you need to go to, I don't know where, Windsor or something. That's right. Workers' comp will send a car service for you, and then they'll bring you home, and it doesn't cost you anything. Why? Because workers' comp is responsible for transportation to and from your doctor's appointments. So most people don't know that. Most people cancel appointments because they don't have transportation. You have to notify your attorney so we can get a rapport with the insurance and with the attorney on the other side, if there is one, to tell them that our client's going to need transportation at least a few days in advance. They provide transportation, people. They do. Now, a lot of people prefer to take their own cars and get the mileage. You obviously don't get the mileage and the transportation, but I got to tell you, if a lot of my clients, they don't like to really drive too much in the car, they're uncomfortable, and they want their spouses to go with them, but their spouses can't go with them during the week, so they cancel their appointments. They do this or that, the other thing. Comp will pick you up, and they will bring you home. So it's a car service. So guys, use it. Why wouldn't you, right? If you have an IME that's in Hartford, I wish I knew this when I got hurt at work. Charlene, I hear that 10 times a day. So I'm sorry. Again, I see your comments here. This is why I do these videos, so that you learn it before. So if you get hurt at work, you remember, right? So again, you have a doctor's appointment, need to get to it's an IME. I don't care what it is. One day you don't have a car. One day you need your oil change. One day your wife has your car. One day your husband has your car. Tell your attorney a couple days in advance. They'll arrange for the car service. It's easy. No cost to you. It doesn't come off the end of your settlement. Nothing. No cost to you. Workers' comp insurance pays for it, okay? I can almost guarantee most of you didn't know that. Why? Because for some reason, people that are hurt at work, they're so afraid of rocking the boat. You're not rocking the boat, people. You're using benefits that are entitled to you. You don't get to bring a claim for pain and suffering in workers' comp. You don't get paid for that. So use the benefits you're given, okay? Also, lastly, you get to choose your doctor. If you're a network, if you have a network like Harvard Healthcare or Yale, they have a list of physicians you can choose from. But all in all, guys, you can choose your doctor. Isn't that amazing? But here's the problem. If you go to Concentra or Occ Health, where they like to send you, and you go 2 or 3 times, The more times you go, the harder chance you're gonna be able to choose your doctor, because comp finally says, depending on the commissioner, Brooke, what are you talking about? Your client went 4 times. He obviously liked this doctor. I'm not letting him choose his doctor shopping. So again, the reason why you should get into attorney in the first week. I'd say one of the first appointments you make is with a lawyer for comp. I don't care what anybody says. Everybody has their own opinions. I'll tell you, every comp case is different. I can't name the last comp case that I had provided this information to that didn't change their lives or change their case. So I do this not to stem up business for me, guys, because let me tell you, we're a busy firm. It's fantastic. And I do this because you all deserve to be educated. You all deserve to know that there are lawyers out there that know what they're doing, that are good at this job. It doesn't have to be one dead end after another or one lame attorney after another. You get the real deal, and that's it. I challenge any comp attorney to come out and tell me that they do as much as we do in educating their clients as we do. I put time, I volunteer my time. I sit with people, they come in my office. They're like, Brooke, I'm not looking for an attorney, I just want to know what to do. Step into my office. I'll happily tell you all about the comp system. I'll sit with them for an hour, have a mug, drink coffee, have a soda, whatever. I enjoy doing it, it's why I went to school. So again, guys, I'm going to wrap up here. I know it's late. We have a lot of people on here, which is fantastic. But if you or somebody you know has been injured at work, call me, 203-399-0000, extension 1. That takes you to my case intake. They're going to ask you a couple questions, get it over to me, and then I call you back within a few minutes. I just like to get an idea of the case first because I don't want to waste your time. And I obviously want to make sure I give you the best advice possible. You can text us at 203-399-0000. You can email us at Brooke, BROOKE, at gofflawgroup.net. You can follow us on social media. Here's obviously our Goff Law Group page. We're almost at 6,000 followers. It's fantastic. So Google Goff Law Group and you'll find us. Also exciting news is that I live in West Hartford, and West Hartford has just launched a WeHa Express. So what it does, we're a proud sponsor. We're on the driver's door. We have a huge, I can't really see it in the picture, but a huge sign. And what it is, it goes along with our anti-drinking and driving campaign. And it does is, if you live in West Hartford, it picks you up for free because it's paid for by us, the sponsors. Picks you up for free, brings you into the center, and then brings you back home. It prevents people from drinking and driving, and it clears the roadways. So it's a great program, and we hope it spreads to other towns as well. We'll definitely do whatever we can to be involved in the spreading of the program. Listen to our radio show 104.1. This week we'll be talking about MedPay benefits on 104.1. I know that's part of it, and we'll be talking about letters of protection. If you're in an accident, how you can see a doctor if you don't have health insurance, or if you have state insurance, how you can see other doctors that aren't covered in your plan. And again, guys, just like I said, always feel free to reach out. You're never a bother. Reach out to me. Once in a blue moon, if I don't get back to you within like a couple hours, understand I'll get back to you by the end of the day. I just may be in court. Most of the time I'll just text back and I'll say, hey, look, I'll follow up with you shortly. So again, guys, thank you for following. Thank you for watching this video. I appreciate it. I hope you learned something. Please feel free to comment. Please feel free to Facebook message me if you have any comments or other concerns about your own case or a friend's case, and add me to your Rolodex. I should be your first call for a workers' compensation attorney in Connecticut. My office, we do it and we do it right. And we go at it at 100 miles an hour, and we take care of business. Thanks, guys. Have a great night. Enjoy your weekend.